In this section, we'll look at the laws of Mexico. And it's the federal law on the protection of personal data processed by private persons. Similar to the EU provisions, the key difference is it does not restrict export of personal information to countries without adequate data protection. Additionally, the data controllers have greater responsibilities in Mexico. The law broadly applies to all companies privacy processing and handling a Mexican resident's personal data, either any identified or identifiable individual. So some of the principles are legality and legitimacy. Controllers may not violate any legal restrictions on collection or processing of personal data, and consent must be given before the personal data is collected. May be inferred if the individual receives a notice and doesn't respond, but otherwise verbal express consent is required. Express consent is required. It's either verbally or in writing or electronically or by some unmistaken indication. And the users have a right to revoke consent at any point in time. Notice and information. The controllers must provide a privacy notice describing what information is being collected and why. And there's certain prescribed information that must be on those notices. Quality. The controller is responsible for ensuring that the personal data is correct, up-to-date, and relevant, and once no longer needed, must be deleted. Purpose. The data can only be processed for the intended purpose. Fidelity. It presumes that a reasonable expectation of privacy. The law prohibits obtaining information deceptively or fraudulently. Proportionality. Data may be processed as necessary, appropriate, and relevant, and you must make reasonable efforts to limit the processing period. Accountability. Data controllers are responsible for ensuring compliance with Mexico's privacy laws. In addition to privacy, the data controllers must implement physical, technical, and administrative data security measures, but they don't specify what those data safeguards are. But you must consider the following factors: the inherent risk for the type of data that's being collected, the sensitivity of that data, the technological development, and potential consequences for individuals if security is violated. Should understand the number of data subjects, the risk factors, and previous vulnerabilities that have faced the company. So again, if you use a data security framework like the NIST Cybersecurity Framework, ISO 27001, 27002, or NIST 800-53, you should be adequate in those security safeguards. The regulations do indicate that what the controller should do at a minimum. That's the inventory of all processing systems and personal data, determine the duties of personal data processors, conduct a risk analysis, establish, implement, and audit security measures for personal data, conduct a gap analysis to determine missing security measures, develop a plan to fill those gaps, and conduct security reviews, vulnerability analysis, and penetration testing, and provide security training for all employees who process personal data, and maintain records of personal data storage media. Controllers must document all of these security measures. And in the case of a breach, the controller must conduct an exhaustive analysis of the breach, and if the breach significantly impacts the data subject's property or rights, the controller is required to notify the data subject without delay. Notice must include description of the breach and an inventory of the types of personal data potentially compromised, the recommendations for how the data subject may protect their own interests, and corrective actions the controller has put into place, and instructions to obtain more information on the breach. The controller must conduct a thorough analysis of what caused that breach.